Hello friends, how are you? Today I will discuss the important conceptual perspective of section 7 and section 13(d) in light of judgment of concerned Honorable High Court, wherein the accused who was convicted by the concerned trial court has been acquitted by the Honorable High Court on the ground that there is no pendency work. So these words are sufficient to help us to conclude that pendency of work is one of the most important criteria for the prosecution and conviction of the accused under the Prevention of Corruption Act, because pendency of work usually generate the motive, and motive or reward inter alia form the basis of prosecution under section 7 of the Prevention of Corruption Act. If there is no motive, there is no reward. In that scenario, it could not be said that the accused has voluntarily accepted the alleged bribe, or it could not be said that the accused was knowingly accepting the same as a bribe. So these are the important fundamental. We have to understand the conceptual perspective. So before proceeding further, I request you to all, please have a copy and pen with you. Please note down the points which I am going to narrate you and apply the same in your case. And if the case facts and circumstances are resemble with your case, then definitely you could be succeeded. But the most important core point or the technical point involved in this case is that the concerned accused has no pendency of work as far as the complainant work is concerned. So I am going to start the presentation. Let's move on the screen. Friends, it is a recent judgment which is passed by Honorable Karnataka High Court, wherein the accused has been convicted by the concerned Special Judge Prevention of Corruption Act, Belgaum, which is dated 2nd of Feb 2013, and he preferred the appeal. Please note down that whenever you are convicted, you have a right to file the appeal as per section 374 of CRPC. This inter alia gives the right to the accused to make the appeal before the Honorable High Court in case of conviction. Now we have to understand the facts of the case, which is quite important in our case before proceeding further. Now make the heading the fact of the case. In this case, the prosecution is that the complainant was working as a president of a particular society and accused was working as CDPO in a particular place. The society has lent particular hands to CDPO office, including the complainant, for operating the computer provided under the Protection of Women from Domestic Violence Act. So this is a basic fact. In this regard, it is agreed that the complainant and the computer operator were required to pay honorarium salary of rupees 1,000 and 3,000, and salary was enhanced to the tune of 2,000 to messenger and 5,000 to computer operator. This order was given with effect from April 2010, but notification was issued in the month of June 2010. The honorarium for the month of July 2010 to the tune of rupees 7,000, and arrears of honorarium for the month of April, May and June to the tune of 9,000 was to be received by the complainant as the president of the particular society. The complainant used to receive the said amount and disbursed to the concerned computer operator after realizing the check in favor of the concerned society. The accused was working as CDPO, and being a public servant, he has demanded illegal gratification, means a bribe of rupees 9,000 from the complainant, and assured him that his amount will be paid after getting the check. The accused was working as CDPO, and being a public servant, on 5th of August 2010, he demanded illegal gratification, means bribe of rupees 9,000 from the complainant, and he was assured that the amount will be paid after getting the check in cash, and accordingly complainant got in cash check. That is very important, and this is indication of pendency work. The said work that was pending was not pending when the alleged demand was subsequently converted into the successful trial proceeding. Got the point? Now it is clear. The accused again insisted for payment of illegal gratification on 16th of August at about 11 am on the strength of complaint filed by complainant. Trial was conducted in CDPO office, and accused demanded and accepted the alleged amount from the complainant for discharge of his duty illegally. It is further alleged that by abusing the official position as a public servant, he obtained the pecuniary advantage to the tune of rupees 9,000, and therefore he has committed criminal misconduct also. On this allegation, investigation has been commenced, and finally charge sheet has been filed against him under section 7 and 13(d) of the Prevention of Corruption Act. So these are the basic fact of the case. In response to the summon, accused appeared before the trial court through counsel. The trial court framed charges and accused pleaded not guilty and claimed to be tried. The prosecution, in order to prove the allegation, has examined the witnesses and exhibited the document. On closure of the prosecution evidence, the statement of the accused has been recorded as per section 313 of CRPC. Accused denied all the incriminating material evidence appearing against him and claimed that the case is false. Trial court, after appreciating the evidence on record, convicted the accused for the aforesaid offence and imposed sentence as per the protocol. The appellant accused challenged the said judgment of conviction and order of sentence passed by the concerned trial court, contending that there is a delay in filing of the complaint. Please note down this point. And sending of FIR to the court. This is another point which has not been satisfactorily explained by the prosecution, because delay in FIR and sending delayed FIR to the court are two vital factors that has to be explained by the prosecution. And if they are totally failed to give the plausible explanation or satisfactory explanation, in that scenario, it is totally fatal for the prosecution. The trial court has failed to appreciate the defense of the accused that complainant has only returned the borrowed money from him, which he has accepted. The accused never demanded nor accepted any illegal gratification, means bribe, of alleged 9,000 for issuing check, and therefore recovery of money from the accused is itself not a ground to conclude that he is guilty. The approach of the concerned trial court is contrary to the law, evidence on the record, and he requests to set aside the judgment of. Therefore, he requests to set aside judgment of conviction, and further request is made to acquit the accused from all the charges and to set him at liberty. Court has heard the argument of both the sides. Now we are coming on the conclusion what type of facts the court has perused while delivering judgment. The court averted in the judgment that after careful perusal of material evidence placed on the record by the prosecution, it would go to show that complainant is working as a president of a particular society. It is a fact admitted. And accused was working as CDPO at Ramdurg. This is also admitted fact. And the said society has lent two hands to CDPO office, including the complainant and computer operator, under the Protection of Women from Domestic Violence Act. The prosecution alleged that the accused has demanded illegal gratification, means bribe, of rupees 9,000 for release of honorarium for the month of July 2010, arrears of honorarium for the month of April, May and June 2010 to the tune of rupees 9,000. These are the basic facts of the case. On the basis of complaint by the concerned complainant, trap was conducted and finally he was caught red-handed. In order to prove the allegation, the prosecution has to prove first the demand and second the acceptance, and both must be voluntary, and it must be for the release of honorarium. For this, the concerned prosecution rely on the evidence of complainant, shadow witness and co-punch witness. And apart from that, the concerned documents had been relied so that the charges against the accused could be stand. The prosecution, to prove that the accused is public servant working as CDPO at Ramdurg within the meaning of Section 2C of the Prevention of Corruption Act, for this they have relied on the testimony of PW5, who is assistant CDPO, who deposed to the effect that the accused is working as CDPO at Ramdurg. And PW6 is SDA working in the same office, also deposed to the effect that accused is working as CDPO. And apart from that, the copy of attendance register, that is Exhibit P14, defense statement of the accused, Exhibit P29, entirely clear the fact that he is working as CDPO, and that's why the said fact is not disputed, and therefore the prosecution duly proved the fact that the accused is a public servant with the meaning of Section 2C of the Prevention of Corruption Act. Although Section 21 of the IPC defines the concept of public servant, but we have to read the definition of Section 2C of the Prevention of Corruption Act. The direct witness to speak on demand of illegal gratification by the accused is complainant, who had filed the complaint and produced the conversation between him and the accused. That is very important. Wherein the accused has allegedly demanded the bribe, and said conversation is converted in the form of CD. It is also produced on the record. The prosecution relies on evidence of shadow witness and co-shadow witness to prove the entrustment. And apart from that, the voice of conversation between the accused and complainant has been recognized by the concerned witnesses, who is working with the concerned accused. Investigating authority is also examined in the case to sustain the concept of fair investigation. On careful perusal of the evidence of PW2, 3, 4 and 11, it would go to show that they have spoken about the complainant as president of the concerned society. And it is fact on the record that he has provided two hands to CDPO including complaint for operating the computers provided under protection of women from domestic violence act. Complainant was also working as a messenger to serve summons under the said act. The honorarium for the month of July 2010 amounting rupees 7,000 in respect of messenger and computer operator was due, and arrears for the concerned months were also due, and that's why the alleged amount has been demanded by the concerned accused as a bribe. Check could be given and it could be encashed. On 5th of August 2010, that is very important, the complainant encashed 2 checks. Thereafter, accused insisted to pay the bribe and demanded the bribe and threatened that in case the bribe is not paid, the outsourcing with the concerned society will be cancelled. The complainant was not willing, and that's why he has filed the complaint before Lokayukt. He also produced a mobile containing conversation between him and the accused, which is also produced in the form of CD. That is very important. It is a private conversation by using a private mobile phone. The complainant had produced 7 currency note of rupees 1000 denomination and 4 currency note of rupees 500 denomination. Total amount of currency note was 9,000 rupees. The said currency note were simmered with phenolphthalein powder and currency note were counted by concerned witnesses. And concerned memorandum was also prepared to note down the number. Thereafter, the currency note were and complainant was instructed to give appropriate signal once the payment is done. Complainant was also provided with a voice recorder to record the alleged conversation. Accordingly, the interestment Panchnama was prepared and photograph as exhibit P6 to P13 were taken. Thereafter, the concerned team left the Lokayukt office, and on reaching the outskirt of the Ramdurg, complainant contacted the accused. That is very important. So it is not the accused who contacted the complainant. It is clear that it is the complainant who has contacted the accused, not the accused who has contacted the complainant. But at that time, surprisingly, the accused was not available. And this is showing the intention of the accused. If he is having the intent to accept the bribe, then definitely he would be present, he would make the call. But such absence of element inter alia shows that he is not having any manshriya, means the bad intention, to accept the bribe amount. And even though he was not present on the spot, on the next day, means on the day trap was filled. The complainant and Pancha witness came to a particular place and where they were instructed to wait for PW11. Thereafter, they went to CDP office at Ramdurg. Complainant and PW3 shadow witness were duly instructed and sent them to the office of accused. Shadow witness was waiting near the door of accused office, and another punch witness along with Lokayukt officials were waiting at some distance from the office. So it is clear that these persons have not seen the incident, but they are shown that they have seen the incident. That is very important point. The complainant asked accused to reduce the money since employee may not sign the voucher, but the accused demanded 9,000 rupees and complainant paid the amount. Accused accepted the alleged amount from his right hand and told that in connection with some other transaction, 500 rupees is required to be paid to the concerned person and returned 500 to the complainant. Accused kept the remaining amount of rupees 8,500 in his backside pant pocket, and therefore complainant on coming out of the office gave signal to the concerned team. Arrival of Lokayukt staff, the complainant showed accused and stated that he has demanded the money. The accused produced the amount from the back pocket of his pant. On making the inquiry, he submitted that on inquiry about 500, the complainant has produced rupees 500 note since the accused has returned the money. That is very important. The same was seized under the trap Panchnama, and which has been identified by the concerned witnesses. The hand wash has been done, the wash of pant has been done. The concerned article has turned into a pink color, which shows that the concerned accused has touched the money and put the same in his pocket, and therefore the phenolphthalein test was found to be positive. Accused right hand and left hand was collected in separate bottle, and pant wash was also collected, and conversation between the accused and complainant was recorded in the voice recorder and converted the same in the form of CD. The conversation recorded in the consent CD was played before the consent person, means the witness number 5, who is colleague of the accused and who has identified the alleged voice. The trap Panchnama has been prepared. An entire process of trap was photographed, and on the other hand, it is a defense of the accused that he has some financial transaction, means he is on the lending theory. In this regard, he has received the said money from the complainant, and it is a repayment of loan amount, it is not the bribe amount. And that's why he tried his best to give the satisfactory explanation of the alleged recovery. The latest judgment in this regard is of Neeraj Datta versus State of NCT, which says that the proof of demand and acceptance is sine qua non for the prosecution of accused under the Prevention of Corruption Act. And the court emphasizes also that demand and acceptance must be proved. These are the foundation facts. If these facts are not proved, the accused could not be prosecuted. And apart from that, the presumptions come into motion only when the prosecution proves a fundamental fact. If there is no fundamental fact, the presumption under section 20 could not be drawn. And apart from that, the judgment of Jattar Singh versus State of Punjab is also relied, in which it is held that the demand and recovery must be proved and it should be voluntary to sustain the conviction. In case Anathanama versus State of Telangana, same principle has been retrieved. The proof of demand of bribe by the public servant is sine qua non. If it is not established, the accused could not be convicted. So we could have a crux that demand and acceptance must be voluntary and it must be a bribe, and it is sine qua non for the establishment of the offence under section 7 and 13(1)(d) of the Prevention of Corruption Act. In the present case, it is felt that the money has been recovered, but his defense is that he has some financial transaction with the complainant. In this regard, he has received the amount. In this context, it is profitable to refer the defense statement given by the accused at the first available opportunity when the trap was effected. The accused in the defense statement made plain statement that he was having transaction with complainant and complainant used to take money from him as loan. And the accused has given money and thinking that he is giving back the loan amount, but the receipt of said money is not the illegal gratification, rather than it is a refund of the loan amount. And therefore the accused has taken back the amount by presuming that it is a loan amount. Okay, na? So there is no ill intention on his part. So it is a first version statement made by the accused on this spot. Always remember that rule number 47 of CBC is quite important. If they fail to take your written explanation in writing, it is totally fatal for them. After getting the bail, you may submit the same by post or through counsel. It is a very easy procedure. In the present case at hand, it is the evidence of PW2 that on 12th of August 2010 at about 10:30 am, the consent complainant received phone from the accused and he demanded the money. He has recorded the same in his mobile. The mobile number of complainant was so and so and accused was so and so. In view of the said evidence, he claims that the accused has called him over phone and demanded the money. The evidence of PW9 would go to show that he has collected the call detail of mobile used by the accused. Would observe that the statement of PW9 runs contrary to the evidence of PW2 and the complainant allegation, because there is nothing on the record that the accused has used the phone of Vittal to do the same, and Vittal also examined and he never speak anything regarding the same, because this is a connecting evidence and it has been broken. That is a plus point. Apart from that, the investigating officer has not collected the call detail of mobile phone belongs to PW5, and the said mobile phone is a connecting link between the alleged demand, complainant and the accused. And evidence of PW11, who is the investigating officer who is investigating the case till the conclusion, never speak that accused has used a mobile phone of a particular person to make a call to the complainant to demand the bribe. It is better to mention here that PW2 even make no allegation between 6th of August 2010 from the date of realizing the check till 12th of August 2010 that the accused has demanded the alleged amount, even after delivering of check to the complainant, so as to connect the chain of events. So this chain is also broken. And PW2 during the course of evidence for the first time deposed to the effect that even after realization of the check, accused persistently calling complainant over phone and demanded the money. So it appears to be a cocked story, because there is no such allegation or evidence available on the record to sustain the same. And apart from that, the concerned evidences are also missing, and credible connecting evidence are missing, and even there is no connecting evidence which could show that the accused has voluntarily demanded and accepted the alleged amount. The court observed that if the accused has no pendency of work on the date of trap, it is also a plus point for him. It is pertinent to mention here that the accused has already issued the check, and therefore mere possession of tendered money or recovery of same could not be a ground to presume that he is a culprit. The prosecution has to prove that for a particular work he has abused his position, demanded the amount so that the work could be done. If the work is already done, there is no occasion to demand the money. In that connection, court also relied on judgment of Honorable Supreme Court named as A. Subir versus State of Kerala. Apart from that, the court also relied on judgment of Honorable Karnataka High Court's coordinate bench, and by referring all the judgment, The court observed that when the work of the complainant is not pending, in that scenario, it is totally difficult to attract the provision of section 7 and 13(1)(d), and therefore the conviction cannot be sustained, and ultimately the accused has been acquitted from all the charges. So friends, in this case we could easily conclude that if the work is not pending, there is no motive, and apart from that there is nothing on the record to connect the accused with the crime. So in this scenario, the court ultimately acquitted the accused. So it's an important legal update. For such updates, please follow and like my page, and for such updates on time, please subscribe my channel also. See you in the next video. Till then, Jai Hind, Jai Bharat.